So this is LAWS 12066 land law, and we are in week 9, folks, but we are still doing topic 7, and we are in the second week of topic 7 on leases. And tonight we are focusing on probably what is arguably a bit more challenging material, looking at enforcement of covenants after assignment of lease. And assignment can work with respect to either of the parties or participants to a lease. That is, the lessee can assign their leasehold interest, which essentially means that someone else takes over the rights and responsibilities as lessee under an assignment or transfer of the lease. We can also have a sublease, which is where you may carve out a part of the premises to bring in a subtenant, but you haven't actually assigned the lease, you're still the lessee, so that's also possible. The lessor can assign the interest that they have during the currency of the lease. Now, the interest that they have, and we mentioned this last week, is the reversionary interest. So they are the owner of the land. The lessee is the fee simple freeholder under the LTA. But the interest that they have during the currency of the lease, the duration of the lease, is the reversionary interest, because we've seen that the lessee actually has today a recognisable interest in the land, which is expressed through their right to exclusive possession and quiet enjoyment of the property, but fundamentally exclusive possession and certainty of term. So we're looking at assignment, but we're also, importantly, looking at remedies. Remedies, people, is not to be forgotten, because any issues that arise, any disputes that arise, of course, a client is focused on what remedies can I get. And we have two parties to the lease. We have the lessor and the lessee, and we need to think about remedies from both perspectives. Now, further challenge here, folks, is that as we've seen today in modern Australia, and not only in Australia, but we're focusing on Australia and Queensland, the lease gives an interest in land and is recognised as a proprietary right. However, if you cast your mind back to term 1, you will remember we looked at how different types of rights that emerged in property law, and you might remember that initially a lease relationship was actually seen as coming out of like a contract relationship or an agreement relationship. In time, it became a recognisable proprietary right, giving an interest in land, and so it was considered to be proprietary in nature. However, in modern Australia, we have had a further development that, particularly in the area of remedies, where there is and I mentioned this last week, that basically the framework of law, the framework of what we refer to as the general law of leases today, is essentially about commercial leases. Okay, we've also spotted the fact that we've got the the retail shop leases legislation, which looks at lots of land, premises within essentially retail shopping centres, and comes within the definitional parameters of that Act, quite specific, right? And then we've got residential tenancy situations. We're not looking at those in this context. So this framework of law that we're looking at is essentially governing commercial leases, where businesses are being run from premises that are being leased from landowners. Okay. Now, because of this commercial context, we have essentially a commercial relationship between the lessor and the lessee. We have commercial transaction, we have commercial dealings, we have negotiations that are often robust. As a consequence of this understanding, what's emerged is a recognition that in reality, even though this is a property law relationship, there are contractual characteristics. Now, this becomes a bit more, it muddies the waters a bit, because when we start talking about these contractual characteristics, particularly when parties are in dispute, what the law has in recent times recognised, particularly in case law in Australia, that parties actually have right to, when we start to see the relationship in these terms, to contract law remedies. Now, you'll cast your mind back to the law of contract. This is one of the reasons why you've got to do all these other areas of law before you come to me and do my area, because I cast your mind back. Can't cast your mind back if you haven't done it, right? So cast your mind back to contract law, and you know, of course, that in contract, the primary remedy is common law damages. So in the context of a lease, where action is being taken by one of the parties to affect the relationship, the issue then arises as to whether or not there is an entitlement to damages, possibly in the nature of what might be characterised as loss of bargain. It's a bargain being struck between the parties in a contract type nature, and if that relationship has been brought to an end by the action of one of the parties, maybe they're in default with regard to their covenants under the lease, or it's a peremptory act to bring that relationship to an end. Maybe the lessor has acted to try and bring that relationship to an end. Is there an issue with regard to access to damages? Then we come to the more complicated scenario of saying, well, which area of law is appropriate here in terms of remedies? Do we want access to property law entitlement and remedies, or contract law remedies? Can, in fact, we have access to both? In terms of property law, of course, what's being fought over is possession of the land. During the currency of the lease, the lessee or the assignee of the lessee has exclusive possession. Well, if the landlord slash lessor, for whatever reasons, justified or unjustified, wants to toss out the lessee and take back, the premises, then this brings to the fore that, that they're arguing they want that property law entitlement, but what then are the capacity or access to contract law type remedies and damages? This then raises other issues, so that, for example, in contract, again, casting your mind back, you'll remember that parties have rights, for example, to argue repudiation of a contract. Then there is issues around termination. And we've already seen in property law that actually the sort of remedies that tend to be most useful in property law are those that are provided by equity, and specific performance of obligations, or an injunction with regard to certain things. Certainly, in this case, looking to get back the land, or to hold on to the exclusive possession. So this becomes a more complicated picture. And remedies are always alive in a dispute, because a client wants to think about what remedies are available, you have to look at what you're being asked, what side, what perspective. Very important to focus on the perspective that you're being asked to think about remedies. Are you being asked from the perspective of the lessee, or are you being asked to focus from the perspective of the lessor? Yes, you need to anticipate, what's coming at you from the other side, but focus on what the question is directing you towards in terms of the perspective. That's the first thing. The second thing, which will come to the problems questions just momentarily, one of the comments that's made, and I'll highlight this again when we come to it, is that where you've got a mixture of law that seems to be going one way and the other, there's a trap that many students fall into. And they fall into this particularly in assessments and particularly in examination questions. And that is that the law looks to be going this way and that way, and it's all balanced. Oh, it's too difficult, and there you go. Well, I've identified all the law, haven't I? I've discussed the legislation. I've discussed what I think are the relevant cases. What haven't you done if you've just left it like that?
Provided a remedy.
You haven't provided advice to your client. Your client needs advice. And if the question is directing you to provide advice, you need to come down on one side or the other after having, yes, balanced consideration of the competing law, yes, within time parameters, yes. But this time around, I think you're going to find you'll have a bit more time to be focusing on a bit more substantial problem question, a bit more time to allow you to think about these competing tensions, right? In a challenging area of the law, right? But it's really important at the end of the day that you have to make a judgment call. Now, the reality here is this is where a lot of students stumble because they're reluctant to do that. They see the law competing, and they think they've covered their bases, and there you go. No, they haven't. They've certainly covered some bases. They missed the main one. The main one is that they need to ultimately advise the client. What are they entitled to? Yes or no, whatever, okay? The other thing too, people, very important, is as you move through your problem-solving exercise systematically, you can use subheadings for the issues that you think are necessary. That's entirely acceptable, no problem with that. The issues that you're presenting, you need to resolve those issues progressively. How does this issue get resolved? How does that issue get resolved? But if you've got competing law to deal with, okay, then that's where the challenge lies. And if you're given a question that requires you to deal with this competing law, then the purpose is for you to actually resolve this competition in terms of the perspective of you that you're being asked to advise the client or whatever, however it's formed. But you need to really focus in on what you're being asked to do. What is the task at hand in light of a body of information, factual scenario that's as per usual. Right? And not just going through and then repeating all this information and not citing slabs of law. I don't need that. I'm seeing that in the second assessment. Don't need that. Sections of legislation being quoted to me. No, I don't need that. Actually, I know about that, by the way. So I don't need it repeated or reiterated to me. But what I do need is for you to show that you've got competence with the legal framework and that you understand the essential aspects of it and you are applying it, identifying it, yes, discussing essential components and applying it, okay? And unlike with the assignment in the exam, of course, you're not going to be dropping all your law out into footnotes because that's not possible. It just surprises me that we've still got students that like to do that. They like to, it's almost like write a textbook, right? So just discussion, and the only place you see the law is in the footnotes. It's never mentioned that. I need you to discuss the law in your responses so I can see how you're dealing with it. Law doesn't progress in a propositional way as though it's a fait accompli. It is actually, you know, sometimes a bit this way and that, and how are you using the law to actually say that this particular situation should be determined like this. The other thing is you have to carefully scrutinise the facts. Don't make assumptions. Carefully scrutinise the facts. Again, you know, from what I've seen marking the second assignment so far, is that this skating across those nuances of difference that have been deliberately pitched into the factual scenario to get you to work with the nuances of difference in terms of the decided body of case law. Okay, so you need to, that's the part of the test, is to pick up, see whether you've identified that. Right. Any questions at this stage before we launch into the problem questions? Any queries? No, silencio. Eve's looking very serious. Okay, all right. So we've got the Q&A book beside us, right? We should have, hopefully. I'm not going to throw up the Moodle website because there's nothing there that's of relevance further from what we've done last week. So we're continuing on with the question that we were working on last week, which is question 5, okay? And there's the beginning scenario again, right? And then we're doing part C and part D, which is over on page 186. I might just give you a chance to refresh your memory about this. So just have a bit of a look again at the information, particularly focusing on, for example, clause 3 on page 185. So we'll focus, what we're going to start with is we're focusing on clause 3, and let's start with focusing on clause 3A on page 185, and then come across to C, which links back to clause 3A. So we've got a situation here where we've got a fact scenario. Right? You can get this in a question, right? You can get a fact scenario, and then you can get specific information from an actual lease, right? Specific clauses, covenants from an actual lease. So we've got the information there, or the scenario. Then we've got clause 3A, which is about assignment. And then we've got C over on page 186, something's done, which seems to be about that. So just have a look at that. All right, so this raises the issue about assignment and subletting. You can see there clause 3A says that the lessee shall not sublet or assign. So this clause relates to both assignment of the entirety of the leasehold interest and subletting. So a specific clause being put in the lease by the parties, or probably the lessor, unless the assignee or sub-assignee's financial viability and experience in the relevant industry are acceptable to the lessor. And then we come across to C over on page 186, and you can see there's been a purported assignment, and there's information there about the fact that the lessor doesn't seem to be happy about what's happened. And there's a basis or information there about why the lessor is not happy. So there's been an assignment to Danny, but he doesn't, the lessor Wade refuses to allow the assignment since D is one of those office suit types and just doesn't fit in with the neighbourhood vibe of the centre. That sounds like a really good, reasonable basis upon which to refuse an incoming assignee, doesn't it? Now, we need to understand that this is an area that is governed by both the specific clause in the lease. It is also governed by the PLA, and it is also governed by case law. Now, this is what makes this more challenging, folks, right? Is that you've got to work with these arrangements, okay? Just want to show you. So there we have section 121 of the PLA. Now, 121 is a fairly longish section, okay? But it's dealing with this idea of assignment. In all leases, whether made before or after commencing this act, containing a covenant, condition or agreement against assigning, underletting, charging or parting with the possession of premises leased or any part of premises without licence or consent, such covenant, condition or agreement shall, despite any express provision to the contrary, I note those words, be deemed to be subject to a proviso to the effect that the licence or consent is not to be unreasonably withheld, but this proviso does not preclude the right of the lessor to require payment of a reasonable sum in respect of any legal or other expenses incurred in connection with the licence, etc. Don't worry about the next bit, it doesn't relate to this scenario. So this idea of the consent not to be unreasonably withheld, who are we talking about can't unreasonably withhold consent?
Mr. Wade.
Right, the lessor. Okay, so the lessor can't unreasonably withhold consent with respect to an assignment or a sublease according to section 121. But this idea of what has been consented to also requires us to look at the wording of the express clause. So it says that shall not sublease or assign unless the assignee or sub-assignee's financial viability and experience in the relevant industry are acceptable to the lessor. So one of the questions that arises is whether or not the terms of that are reasonable in all the circumstances and then need to be complied with. The other is whether or not there has been whether in this particular circumstance the lessor has unreasonably withheld consent. Okay. So what do you think about that? What are folks' view on that?
Michael, I would have thought that the lessor's ability to reject that application is narrowly focused on the sub-assignee's financial liability and experience within the accounting industry.
And is that the basis upon which the lessor is sought to refuse consent?
No, he's just saying that he doesn't fit in.
Yeah, doesn't fit in. That's a great basis. But do you know, in reality, there's an aspect of that. It's not quite as blunt or as bland, like as bold as that. Okay, it operates in reality. It operates in slightly different ways. So it's really about the lessor making decisions about the types of tenants they want in the complex, if you like, or in the premises. And so, couching it like that is clearly, it's really smacks of discrimination and so on. But again, we've got to go back and we've got to benchmark it against the requirements of Section 121, against what is within the lease itself and how this has been interpreted. And that's the process that you need to follow. But certainly it doesn't really appear that what has been, the decision that's been made by the lessor doesn't seem to be reasonable in terms of the withholding of consent. What about going back to the clause itself? It talks about this financial viability. Do you think that is acceptable in terms of the legitimacy of the clause within the covenant, within the lease between the parties?
I would have thought it was the old adage of cover your ass exercise, making sure that those tenants that are coming in are financial enough to carry on. You don't want empty shops.
Yes. What if we were to say that is reasonable, and what if Danny had issues in respect of that, but we also had this statement by the lessor that he just doesn't fit in? Can you see the point I'm driving at?
I'm looking at the construction of the clause, and you've got A, and then it says and then it's got B. So
yep.
He's got to have both.
Yeah.
He's got to have that relevant experience within the industry, acceptable, and he's also got to be able to pay the expenses.
Yep. No, that's right. That's good analysis of the clause. But what I'm pushing back is, what if he doesn't meet those aspects, and we determine that is a reasonable basis for the withholding of consent, but he is also making this statement about, well, but you just basically don't fit in. Can it be argued that if the latter forms part of the reasons, that it sufficiently colours the basis to actually make it unreasonable, even though it has partly based in what we've considered to be reasonable? Can we do a straw poll? Let me just stop screen sharing that for a sec. Can we do a straw poll? What do you people think? Yes, no? You can vote in the chat box. Yes or no? See, this is where you've got to come down on one side or the other, folks. We need an outcome. I mean, in other contexts, one might say, has it been sufficiently colourable to overbear the otherwise reasonableness of the decision to withhold consent. No. Eve's sort of having half a dozen one way and 6 of the other. I like, actually, it's interesting, sometimes some of your colleagues in your assessments is exactly what they do. Well, he should have done this. Why didn't he do this? Or well, yeah, but you take the facts as given, folks. You have to take the facts as given. You can't, regestate the facts in a way that would suit the outcome you want. It doesn't work. You can't, the client walks in the door with a certain, no, please, can you come back in again? But just talk us through the scenario in this way so it better fits into the law and I give you a better, it doesn't work like that, sorry. But good attempt, Eve, good attempt. This is a challenge, people. It's a challenge, and you have to ask yourself, has it sufficiently overborne the reasonableness? But then you have to also ask, well, what is the consequence of that? That the consequence is that you're also denying the lessor the right to withhold consent if it's on, if there are reasonable, if there's a reasonable basis for doing so. It talks about, as we go back to section 121, it talks about that consent is not to be unreasonably withheld. Okay, and you have to determine whether that's actually what's going on here. You have to determine whether the clause sets up reasonable grounds, firstly, and then you have to decide whether the action itself and the reasons provided actually indicate that no, that's not, it hasn't been reasonable in all the circumstances.
Michael?
Yep, sorry, Peter, yep.
Yeah, I'm gonna get off the fence here.
Oh, very good, very good.
About it. I think that the clause is reasonable. The clause itself, I think, is a reasonable clause.
Yep.
That the viability, the financial viability and the experience in the relevant industry is not something that is too much to be asked for. However, I think that his reason of just not thinking that this guy's not going to fit in is unreasonable, and I would be testing that in court.
And
that's my opinion.
And would you say that statement then overbears any other reasonable basis that may be made that's consistent with the clause?
If he has other reasons that are not stated in this scenario for rejecting the guy, they may override that particular statement. However, just what is stated here, he just says he's one of those office types and doesn't fit in with the neighbourhood vibe of the centre. Who knows whether he's going to fit in or not? Because that's an unreasonable assumption to make. Yeah,
and that's a fair point. And what's important here, folks, is that you are analysing the clause, the aspects of the facts that are relevant against the clause, and the wording of the legislation and any governing case law. Now you can see that's a bit involved. Okay, to do a proper job on something like that, there's it's a bit involved. So it's something you've got to practice, because within a tight time parameter, you've got to know how to do that in a fairly fluid way. You can't be trying to find your way in the exam room.
Sorry, Michael, I'm just asking, what's the basis for that? Because, like, reading in the legislation, does it provide that if someone has good reasons, but then also has, like just a personal dislike for someone, that does that sort of colour the whole, reasonable grounds, that there's some. But does that throw the whole thing out?
Well, that's the whole point that I'm tossing up, yes, and that's exactly right. So the point then is you have to determine what is the actual basis of the decision that's been made, in this case by the lessor, against on the facts that you have. So yes, you've got a clause there that's the basis of being able to withhold consent, but is that being used on as the facts reveal as the basis of withholding consent? And so that's what you've got to determine. And then you've got to determine whether, again, on the basis of the facts that you have, whether that's actually overbearing any aspect that might actually be based in that clause that's in the lease itself. And if it is, and if it's deemed, and if you come to you resolve that in your mind that it's unreasonable, then it will fall foul of section 121.
So in other words, if there'd been a little bit more added onto the back of this, Danny's one of those office suit types who just doesn't fit in with the neighbourhood vibe of the centre, and he's got a bad record of finance. Then you've got a clause that would override that unreasonableness. It
may. That's something that you would have to decide looking at the totality of the facts. But remember again that your task is to interpret the information that you're presented with. And particularly when you're under a tight time frame, you can't be creating more different information to produce a different outcome. Okay? That's not the task at hand. And indeed, as a lawyer, well, in reality, of course, you'd ask your client further questions and you'd elicit further understanding of the situation. But in an exam situation, that's not possible, right? So you have to take the information as given to elicit whether that's been met or not. Right, so let's move on to the next aspect of this problem, which is about not being able to pay the rent. So the non-payment of the rent actually brings us to another section of the PLA, which we'll come to shortly, because this then tosses up what can be done where there have been breaches. Obviously, the non-payment of rent, the lessees haven't paid their rent. And there also could be arguments that Wade has breached lease covenants as well with regard to repairs, maybe, and some other matters. And the information in the discussion there in your Q&A book also talks about the idea of set-off. That is one claim being set off against another, and whether that can work in set off that's recognisable in common law or set off in equity, and how that works. I want us to focus a bit, not so much on that, but rather on this idea of what are the lessor's options here where there has been breach of the obligation to pay rent. Now, we've seen that, we said earlier last week that the rent is not actually a fundamental characteristic of a lease, but of course it's always there, and it's the reason why premises are being let by an owner to generate income. It's not part of what characterises a lease relationship, but as we know, it's practically there, and it's critical from the lessor's point of view. Question then arises is when it's been breached and there's outstanding rent obligation or outstanding rent monies, what can the lessor do? So there are, again, this is where we get into this avenue of property law versus contract. Property law rights would allow the lessor to forfeit the lease. Forfeit the lease and re-enter. Whereas contract law type remedy would actually allow a claim for damages where the lease might be maintained. So the lease isn't forfeited. And this takes us into, I'm just going to share something with you again, the legislation. So you can see there we've got Division 3, this is in Part 8, Leases and Tenancies, Division 3, Relief Against Forfeiture. And we've got Section 124, nice short sections these, aren't they? Sorry about that, folks. This is restrictions on and relief against forfeiture, okay? So sub 1, we'll just have a look at sub 1. A right of re-entry or forfeiture under any proviso or stipulation in a lease for a breach of any covenant, obligation, condition or agreement express or implied in the lease shall not be enforceable by action or otherwise unless and until the lessor serves on the lessee a notice. So there needs to be a notice with regard to this action to be taken, okay? And that then allows the lessor to proceed with regard to forfeiting the lease and also being able to re-enter the premises. So Section 124 has to be complied with. And then there's also this idea of how do we, to stop screen sharing that for a moment, how do we characterise this rent obligation? Now, we've got a response there from Eve. Do you want to expand on that a little bit, Eve? Or
I was having a flashback to when I read it, so now I'm looking to see which book I read it in.
You knew I'd come at you on this, didn't you? So, what is this? Can we just... I know this is casting your mind back, folks, to contract law days, but what is the significance of the characterisation of terms in a contract? If we refer to a term as an essential term, what does that mean? If you breached an essential term, what does it allow the non-breaching party the option of doing?
See,
Terminate the contract.
Say again, Michael?
Terminate the contract.
It's
repudiation? Is it repudiation?
Yes, repudiation. So repudiation is stronger actually than this is sort of, because termination only brings the rights and entitlements to an end from that point, whereas repudiation basically unravels the entirety of the contractual obligations. So this distinction between whether or not a term is essential, or there's another word we use that starts with an F.
Fundamental.
Fundamental, that's it. Very good, very good. We're playing charades here, aren't we? I was trying to think of how could I possibly characterise fundamental. So, essential or fundamental term. Now, this is where, and you can see again in your Q&A book, and you can refer back to your case book as well, starting to talk about the significant cases of Cheval and Progressive Mailing House and Tabali, High Court decisions that said that really where we've got the breach of a fundamental or essential term, then that's what takes us in the direction of being able to get contract-like remedies. That is common law damages, and that takes us into this idea of repudiation. That starts to sound very much contract law language, and you can see that there's a discussion in question 6 about the idea of lease repudiation and applying that to lease relationships, even again said property law relationships, and this even escalates more, this overlay of contractual thinking in terms of these lease relationships. We're not going to get a chance to go on to question 6, but you can have a look at that. It's more an essay style question, and I want to focus more on a problem solving type question. But you can have a look at that discussion in your own time. So this then takes you into this discussion around the, to what extent can you access those? You can see, for example, over on page 191, Progressive Mailing House in Tabali is quite a serious case involving multiple and prolonged breaches by the tenant, where it was held that absolute repudiation could be demonstrated by a failure to pay rent coupled with an abandonment of premises. Now, what's the nature of the breach that's occurred here? Has it been that serious, Peter?
The nature of the breach is the failure to pay the rent.
How long have they failed to pay the rent?
3 months.
And when is rent normally payable?
Sorry?
Rent is normally payable when under the lease?
It's normally paid monthly in this.
Payable
particular
monthly in advance? What?
Yeah, that's right.
Monthly in advance.
Yeah.
So they're 3 months in arrears.
Hmm.
Is that serious enough in the Progressive Mailing House type context to allow us to proceed to get this contract law type remedy?
They have to be given notice to remedy the breach, and that's usually 3 months' time under section 124(1).
Yep. That's
and
good.
And if there has been no right of, there's no right of forfeiture unless if the breach has been waived too. So if nothing's been done about it, he's elected to still keep it as being the landlord's elected to continue on without giving them notice of the breach. That and his intention to do something about it and getting him a reasonable time to remedy it.
Yep.
He's really virtually waiving it, and it could be
Yep.
construed as being waived.
No, that's a good point. So we need to scrutinise the lessor's actions, not just the actions of the lessee that's amounted to the breach. In this, we're looking at the breach of the lessees with regard to payment, non-payment of rent. I mean, it's arguable that the lessor has breached some of his obligations too. But in this issue of the breach by the lessees of payment of rent, then we examine the conduct of the lessor, and if the lessor has allowed this to continue and hasn't dealt with it, then it could well be that we can say that the lessor, by his actions, has waived his entitlement to repudiate the lease, and indeed is treating the lease as continuing on foot, and then he might just have to revert back to his property law remedies, and he needs to follow due process to access those. The reason he has to follow due process under the Property Law Act is because of the serious consequences that will visit on the lessee. He's effectively if he exercises his property law rights to get relief, that is to forfeit the lease, he's actually, in effect, tossing the lessees out. That's very significant because their interest in the land is exclusive possession. Okay, so again, it's very important that due process that's required under the legislation be followed for him to get access to those property law entitlements. I just want to take you, folks, if I can, to your casebook. And you've got an extract there from Progressive Mailing House in Tabali, and I would encourage you to have a look at that. But just on page 814, yes, we have ticked over 800 pages, folks. Yes, we have. 8.184 progressive mailing house in Tabali attenuates differences between the law of landlord and tenant and the law of contract. Moreover, the fact that the source of the parties' rights and obligations was an agreement for lease was irrelevant. There is no difference in principle between an agreement to lease and an executed lease. It follows from this decision that where the tenant has repudiated the obligations under the lease, the landlord may accept the repudiation as discharging both parties from further performance, terminate the lease, and recover loss of bargain damages for loss of the lease. Now, if in fact those loss of bargain damages are available, then that will also include and extend to include any amounts with regard to reletting or amounts that may be lost because the property actually can't be relet, right, after this arrangement has been brought to an end. There's further discussion there about how do we go about assessing the damages in that situation. And then there's a further discussion down on 8.188 with regard to the tenant's repudiation. The landlord may accept the repudiation as discharging both parties from further performance and terminate the lease. Again, along the contract law type thinking around this in this area. And then there's also a discussion at 8.189 of the Cheval case, which I've already referred to in this regard. So encourage you to have a look at that. And also the Gumland property case at 8.190C, which is the more recent High Court decision, so that you've got progressive mailing house decided in 85, and then you've got Gumland property decided in 2008. I mean, these are Gumland property, I'm sure, as you looked at that when you did your contract law studies, but not that it's sitting right there in the forefront of your mind, but that just if you have a chance to have a look at it, which, and Gumland refers to progressive mailing house in Tabali, it will just refresh your memory around how that is the current situation of the law in this regard. So that's something that at the end of the day, right, as for the first part with regard to the assignment, okay, so we didn't go back, but in terms of the second part, we were looking at the latter part of C and also into D, in particularly D with regard to what had gone on in that regard with regard to non-payment of rent and so on. Okay, so this then takes you into this area of what type of remedies are appropriate. Are we looking at property law remedies? Are we looking at these contract law type remedies? What are the requirements for that? Again, the impact of the Property Law Act and significant case laws we've seen. And then in the end, you need to resolve this and you need to make a decision about whether or not there is access to the property law type remedies, or that's most appropriate, or whether in fact, in this case, the lessor can access these contract law type remedies, for example, damages in the nature of loss of bargain and what that entails and what they might be entitled to. I just want to draw your attention to a couple of points made in the comments and the keep in mind on page 191, okay? And I think this is quite important to focus on. Just the third line there, so this is, like, comments recognised as a relatively complex scenario, right? And then the examiners make this point, that the student has failed to close each topic properly by neglecting to reach a conclusion on many of the issues. That's the point I made earlier. A good traversing of the material, a good traversing of the situation under the law but has failed to wrap it up and give an outcome on the issues. It's very important, people, that that's what you do. You need to give an outcome on the issue that you are discussing. You can't just leave it in abeyance. And there's a great temptation by students when the law is a bit at variance and it's not clear to leave it in abeyance, because it's you have to take that next step of providing an outcome which is effectively the advice you would give a client. It's a simulation, folks, in a way, of what you would be required to do in practice. Yes, it's artificial in the sense that it's under the parameters of an exam, it's a tight time frame, all that sort of thing. We understand that. Yes, that's all acknowledged. However, I have to say to you that in practice, you can have a client that walk in the door, or, you know, there's the old days, walk in the door. They probably don't walk in the door. These days it's online or it's telephone call or whatever. They want the advice yesterday. They want the advice by close of business. They call you at 3 o'clock in the afternoon or they email you. They want to close a lease by 5 p.m. So they need your advice in a couple of hours. Or they've got a dispute going, they're not sure what to do with this lessee or whatever, if you're advising, acting for the lessor, and they're giving you a couple of hours, if that, to give them the advice. You have to take the information at hand, you have to inform yourself as best as possible, be aware of the relevant aspects of the law, and give advice to the client that is appropriately grounded in the law, is practically informed, and is advice that the client can follow. They're not looking for a historical narrative around the law, I can tell you that, but at the same time, they're interested in practical advice, but you need to make sure that it's underpinned by a good understanding of the governing law. But they certainly need an outcome in terms of the question they've posed or the query they've put to you. So this is a really important skill that you need to practice while you're in law school, because it's something that is what you'll be required to do when you emerge out there into practice. Okay, so that's one point. And the next is that if you're being asked to advise a client, go back to the examiner's comments. If you're being asked to advise a client, make sure you do. Okay. And actually interesting, you know, I said this in my earlier marking the assessment. So it's quite sure that in that first question, I said that you were giving a presentation to partners. I was quite sure I said that. And yet you'd be surprised what I've marked so far. I'm just getting a narrative discussion. Not universally, and I've marked about 10 or 15, I think, at this stage. Not universally, but you'd be surprised. Some are just giving me a narrative discussion. It's not really answering the question. If I ask you to do something particular and you choose to ignore it, can I suggest that you do that at your peril? Not good idea to ignore specific instructions. And if a client comes to you and asks you something specific and you decide to ignore it, not a good look, folks. The client's not all that impressed. So, and then the last part of that is, just around the summarising and concluding the arguments. Okay, that's a good point. So, and then just to keep in mind this idea of needing to make conclusions, and then don't leave things hanging without drawing them together and being producing, as the last point there, the last one, definitive answer. Right? So it's not the case that the outcome is absolutely without question one way or the other. That's not the point. The point is that on balance, having considered the scenario, having considered the information, having explored the issues against the relevant legal framework, this is what you are advising should be the path that's followed by the client. Okay, so that's and you need to also be appreciative of the practical context of the client. You know, what situation are they in? What business situation are they involved in? And so you saw there in the problem question that there was, you know, it was about a, you know, accounting situation, and then one of the clause with regard to withholding consent of assignment was about the financial viability of the incoming S&E when a lease was being assigned. So those practical features are also something you need to have connection with in what the advice you're formulating. It's not just an academic exercise in terms of, well, this is the law, but it's clearly linked back into those practical features. Okay, so that's important.
Michael, it seems to me that reading over that question and coming to an answer, irrespective, or I shouldn't say irrespective, but part of the issue within the contract is not just what's written in the contract, but as we sort of expressed last week, it's the actual conduct of both parties too. Whether they actually have done or not done something is actually relevant to which tangent you should move down.
Absolutely right. Absolutely right. So what you are doing is you are analysing the documentary connection, if I can put it like that. Sounds a bit unusual, isn't it? But the documentary connection between the parties. So what they've reduced to writing. In this context, we're looking at a property law instrument, a lease, but it is increasingly, in commercial terms, being viewed as contract-like. It's not exactly a contract, but it has contract-like features, and it's viewed like that at this end of the business when we're talking about remedies. Right? When we're looking at other aspects of a lease, we're very much looking at it in property law type terms. Okay, but when we're down to get to the remedies, when the problems have arisen, the courts have recognised that contract law thinking becomes relevant. Okay, but absolutely, you need to be looking at their conduct and the decisions they're taking, and scrutinise the information that you're being given that reflects their decisions, reflects their conduct and their actions. And as we know, that's suggestive of how we should then go about applying the law to what's done, and whether they've acted reasonably, whether they've acted, against good conscience, and so on and so forth. So absolutely. As well as the specifications that now exist within the legislation that governs this area. Property Law Act, quite critical, and also the Land Title Act with regard to torrents. Now, just as we draw up, just a little bit over 8, sorry about that, I just want to share something else with you. So here we have the Property Law Act Review, 2018 review. Now, I've already indicated to you there's a huge section on leases, huge section. You don't need to read all that, right? But it's interesting, for example, to go back and have a look at, and again, these are proposals. So in a problem-solving question, this is not really, you don't need to bring this up, but it is interesting that we looked at 121 and 124. So here we have on page 668 of the review, final review, we have a nice little correlation between these provisions under the PLA and what are the equivalents in other jurisdictions. I thought that's interesting. Okay, I know that several of you are in other jurisdictions, so I thought that was interesting. And then if we just pop down to the recommendations, we will see this is what's been recommended with regard to 121. Modernise and simplify the language, exclude the exception in relation to building leases, provide a simpler model for the issue regarding improvements, structural alterations, so that's further detail in 121 that we can have a look at. Impose a requirement on the lessee to provide all of the information about proposed S&E. Impose a requirement on the lessor to notify the lessor, so that more more structured way of doing it, and enable the lessee to recover damages from the lessor where consent is unreasonably held. So trying to also build in to the legislative provision some of the developments that have taken place in the general law, okay? And you can have a look at that yourself. And then just want to come down to show you section 124. So there's a long discussion, or reasonable detailed discussion about 124. And then we come down to 124, and again, 124 should be repealed on the basis that the recommendations for all of Part 8, Division 3 be adopted. And then they provide an example of how they believe section, what's quite long, a bit longish, 124 should operate. So again, it's not a case that you need to, have a working knowledge of this, but it's just interesting to be aware of these developments. And you know that for the purposes of your exam, and I'll just stop screen sharing that now, that this topic is assessed in Part B of the exam, which is the problem-solving questions, not the policy questions. I've made that quite clear in my exam advice. So these reform proposals not bearing for that purpose, but it is interesting just to see what's being proposed, and if these proposals are taken up, not yet done, then we will end up with legislation that is modern, is in plain language, and does deal with some of these developments that have happened in the general law, and they will find their way into the legislative scheme, and things will be made a bit more clear and a bit more straightforward for everybody, which hopefully will be for the better. Well, there we are, folks. Leases Part 2, where we've dealt with assignment and remedies. And
on a quick side note, Michael, I noticed you sent out an email today in regards to adding further materials to the Moodle site. I went and had a look today, and I couldn't actually find them in section 7 and 8. Where did you put them?
That's the, I think, those additional materials were in relation to topic 8, not topic 7. So that was in relation to social housing. There's a number of additional sources that are identified there. And I had a query from a student about, well, do I need to read all these? And so I thought, well, I'll clarify that for the benefit of all. So that email that I sent out today, I think it was today, was about topic 8 in regard to social housing. And what I've indicated in that email is that with regard to topic 8, which is on the exam as an option in Part A, as you've seen, I've indicated to focus on the developments in Queensland, the policy developments in Queensland, the legislation, Commonwealth and Queensland legislation, and then the international materials that I've given you in the additional resources are really just if you have an interest to have a look at those as examples of things that are being done in other jurisdictions, in America, and so on. And so that's just by way of something additional if you have an interest, but not critical. But that relates to topic 8, social housing. Right, folks, there we go. Leases. How about we finish in the usual way? You can just maybe just drop one. You can drop one thought down. Take away from tonight's class. Assignment. Not assignments, but assignment. Yep. So I'll just finish by saying that, in leases, in this topic on leases, we've got that first section, which is about what type of a lease do we have? Do we have a lease? And then, do we have a lease? What type of a lease do we have? Have we satisfied the relevant formal requirements for a lease? What are those requirements under legislation, both the PLA and the LTA? Don't forget that freehold in Queensland is Torrens title, so that means that leasehold interests can be registered under the LTA, but then there are also some exceptions for short leases and so on. But if leases aren't registered under the LTA, that means you have an unregistered interest in Torrens land, okay? So you need to think about the consequences of that. You need to think about the consequences of complying or non-complying with form requirements with regard to the completion of a lease, okay, under the legislative requirements. And then covenants, what are the nature of those covenants, what type of covenants upon the lessee and the lessor that can be entered into, what are the source of those covenants, both within the lease itself and within the legislation and implied by law. And then tonight we've looked at assignment, that is the transfer of the interest by the lessee, or the transfer of the interest by the lessor, that is the reversionary interest. The lessee can also sublet and the implications of that. And then how can covenants be enforced upon assignees going forward? And then this issue about privity of estate and privity of contract. We didn't go into that in really too much detail, but that sits as a backdrop to that assignment issue. And then remedies. Very important, the issue around remedies, and remedies in property law as opposed to contract law type remedies with leases. Seeing the lease in contractual terms as well as proprietary terms. And this takes us all the way back to the beginning of our studies at the beginning of the year, when we looked at property law and we said, well, how is property law different to other areas of law? And you might recall that one of the areas we looked at was contract. And we said, how is something a contract as opposed to a property relationship? And here is now we're seeing the blurring of the lines, yet again, in a very practical way, in terms of what aggrieved parties can get access to. Right, and Eve's point well made. So having a practical focus at the end, folks, problem-solving questions in the exam require you to have clear, logical structure within time parameters that works through the information, focuses on what you're being asked to address, the perspective from which you're being asked to look at the information, and reflects good understanding of the legal framework, but applies it to the situation at hand and provides outcomes on issues and the advice that the client has been seeking and is part of what you're being asked to do in the context of that exercise. That's all, folks. That's all. We're not too demanding, in property law. It's just not too demanding. He says that a bit tongue-in-cheek, All right, folks, that might do us tonight. So next week we soldier on to social housing, topic 8, which is a bit of a different topic, not included in all law courses. Actually, one thing that's interesting is, so I'll just say that the formal class is now finished. I'll just make a couple of broader comments. I'm just going through a process at the moment, benchmarking, looking at what other law schools are doing in property law, and it's really interesting. People do a whole lot of different things in the way they tackle the material, and the requirements of what we're required to do in these core courses is changing as well. And that's just an interesting exercise. But the property law is demanding, and there's an awful lot. but it's, you know, we have to make choices at the end of the day in terms of what we need to focus on. And we need to have in my view, we need to have a modern and a forward-looking perspective that understands how property law works today, what its relevance is. We certainly need, you know, some foundational material and some notions of the history and where we've come from, but we need to equip our students with the relevant understanding and skills that allow you to see how property law functions in the world and its continuing relevance. So here we go, folks. Next week, moving on to an interesting topic of social housing, which is something that is, you know, dealing with issues around access to housing by people in circumstances of social and economic disadvantage, and also how property law works in that space. So, until then, it's good night from me, it's good night from him.
Night, Michael.